Hello landlords, it's Ernie Garcia, landlord attorney, and today we're talking all about a writ of execution. What is it? How can you use it? Let's get started. Hello landlords, I'm super excited to announce a training course that I have produced that will be launched in the month of September. Look out for it. There's a link on the screen here that you can type into your web browser, or if you look in the description of today's video, you'll see a link that you can click to check out more about Landlording Pro. So what is a writ of execution? So you've heard of a writ of possession, which is that document that is signed by the court in order for a landlord to regain possession of real property after an eviction judgment has been signed and is now final. But the writ of execution is a little bit different. The writ of execution isn't restricted to eviction matters. It comes with any civil judgment. If you have a judgment and an award for money damages, you can use a writ of execution to access non-exempt property from a tenant in order to pay off a civil judgment. So first things first, what is non-exempt property? So let's first talk about the things that essentially a judgment cannot reach. In the state of Texas, a married couple is protected up to $100,000 and an individual is protected up to $50,000 worth of personal property. Now, personal property would be things that are not real estate, that are owned by the individual. Certainly a person's furnishings, their clothing, even their pets are protected and cannot be seized in a writ of execution process. The law protects individuals from the reach of creditors, and so things like a person's homestead is also protected. If the place where they live is designated as their homestead and is the only piece of real property that they own, it cannot be seized and sold at a foreclosure auction to satisfy a civil lawsuit, short of a foreclosure or a process where the courts have already allowed the foreclosure of that property. However, let's talk about a classic example where it would be very simple to determine whether or not property is exempt. Let's say a person owns their own home, but they're also co-owners with family of some vacant lot in the middle of Texas. Well, if you are aware of the ownership interest of that individual in that particular lot, you've just identified non-exempt property. Now, this is real property because it has to do with land, but that property is subject to seizure and can be auctioned off. Now, the fact that they are co-owners with other parties only means that your portion of the foreclosure in terms of your judgment lien is limited to their interest. So if, for example, they are co-owners with two other siblings, well then, in the event of a foreclosure where you are the highest bidder, if it turns out that no other bidders at the foreclosure sale bid, and by virtue of your judgment, you are the highest bidder, you would be a co-owner with those siblings. Also, sometimes people own multiple vehicles. Generally speaking, the rule of thumb is one vehicle per adult in the family, or one vehicle per driver. So that if there are two adult drivers in a family and three vehicles, then one of those vehicles is subject potentially to seizure in a civil claim for a writ of execution. Naturally, if someone owns multiple pieces of real property or way more vehicles than they have drivers, then you have an excellent opportunity for exercising your civil judgment and collecting that judgment with a writ of execution. So how does the writ of execution work? Well, after you have a judgment and it has been made final through the court, there is no ability to appeal and no ability to relitigate the matters that formed the judgment. You have a final judgment that can be executed. That execution comes by purchasing a writ of execution through the court where you obtained your judgment. Now, generally speaking, there are some costs that come with it, including costs to serve the writ. So if you have lost track of the defendant in this case, it may be difficult for you to implement a writ of execution. In order to serve it, you need a physical place where a constable or a private process server can deliver the writ. That's always true with any kind of service of process. So if you have a judgment and you are unsure where the defendant is located, this may not be a great option for you. However, if you know where this person lives or works or both, then you have outlets for personal delivery of notice. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing. Your writ of execution is then processed by the court and then served, usually by the constable, in person to the party who you wish to notify of your intent to seize property from. Now, it always helps if you know of the specific property that you wish to seize, whether you know of vehicles or you know of real property that is owned by the individual. A lot of times these things can easily be found on county websites. There are records that are posted online. Not every county does this, but there are records that essentially could be researched to identify whether or not your defendant owns real property in the state of Texas. If that's the case, you can request your writ of execution and inform the constables as they are serving it what property you wish to seize. Something that happens often in this process is the notice is delivered and a person recognizes that some property that they own is not exempt from seizure. While many things are, if it turns out that the piece of property, real or personal, is not exempt and not protected by the law, then they could potentially lose it. And what happens often is that the judgment debtor, the defendant, will reach out to the creditor, you, the plaintiff, or your attorney, and say, look, what can I do to prevent this foreclosure? I don't want to lose my X, Y, or Z, whatever it happens to be. And so they may come to you and say, I'm willing to pay the full amount of the judgment debt. Well, once the judgment has been fully paid, you no longer have the authority or the capability of exercising your judgment lien. It doesn't exist anymore. And so if you work out a deal and you accept the full payment that you are owed, including interest, of your judgment lien, then the seizure would cease. There would be no foreclosure. And then the last thing you would do is file a release of judgment. This release of judgment will put the whole world on notice that the judgment debt has been resolved and is no longer owed. If you filed your abstract, essentially establishing your judgment lien in a given county, then that should be the county where you file the release of lien. This way, anyone who is researching this particular individual will find that while a judgment lien was recorded, the release of that lien is also there, and so the judgment lien no longer affects that person for whatever purposes that researcher is looking to substantiate. So if you have a judgment and you happen to know of non-exempt property that is held by a defendant and you are able to locate that defendant for purposes of service of process, you may want to consider utilizing a writ of execution in order to collect what is owed to you in a given judgment. Please note that a judgment is valid in the state of Texas for 10 years. And if you have gone beyond 10 years, but you're still within 2 of that 10-year time limit, you can actually revive your judgment and reinstate it. But if you're within the 10 years and you're getting close to it going dormant, by requesting a writ of execution, you effectively increase the lifespan of that judgment for an additional 10 years. Essentially, you can keep a judgment going really forever until you have a good clear path for collection. However, if you've got judgments that are just sitting in a drawer somewhere, you may want to dust them off and see if there is any reasonable expectation that you can collect. And if there is, again, I suggest a writ of execution for any non-exempt property that's out there. You might just have a payday coming to you soon.